Our next speaker is Professor Michael Bridge, and he's an emeritus professor in the London School of Economics and Political Science. As I understand, he's also a professor in National University of Singapore. And we all know that Michael is a leading scholar and authority in the area of CISG and international sale of goods. So we have all benefited from his writing. So we will welcome his speech on the topic about the UK experience. Michael.
Thank you very much, Qiao Liu. And thank you also for your actual invitation to be virtually present in Hong Kong. And thank you, Ewan, for that fine bit of promotional material on behalf of the CISG Advisory Council. Perhaps it should have been labelled an advertorial, or whatever they call these things as they appear in newspapers. So now I'm in the position of having to stand up for or represent the UK experience with the rather tricky question of whether or not this is a matter of UK exceptionalism. So now, let's start with the general background. It's well known that the UK is one of the few major trading nations that is not a party to the UN Sales Convention. We have 93 states, as was previously stated. I think I understand that Portugal has now come on board, so it should be 94 fairly soon, or if not already. And the reasons for this particular stance on the part of the UK, I think I'll state fairly briefly to begin with, before I focus on something which I think really lies at the heart of the whole experience. The overwhelming reason, I think, from my conversations with various parties here, is the sheer lack of enthusiasm for the CISG in the legal and commercial communities of the UK. The Department of Trade and Industry, or whatever it's now called, was always reluctant to carry the CISG forward without substantial backing from the relevant stakeholders. And that, I think, is and was the principal reason why we do not have the CISG in the UK. But in addition to this, and this has been adverted to already, there were fears expressed that accepting the CISG would have a detrimental effect upon the presence of London as a major arbitral and legal dispute settlement centre. I may say more about that later on in my discussion of what the Financial Markets Law Committee had to say about the CISG. It is a factor without any doubt at all. And when I was present at one particular meeting chaired by Lord Mance quite some years ago now, there were strongly held views about the undesirability of major law firms having to learn more law. Why should we have to, something has popped up now, why should we have to learn another legal system? Well, it's fairly well known, isn't it, when it comes to the contract of sale, that the most likely law to be the governing law is the seller's law rather than the buyer's law. And to the extent that when it comes to hard goods, the UK is an importing country more than an exporting country, it's perhaps a little bit surprising that this particular feature should not have come across the screen of practitioners. And it may well be that major London law firms are content to have issues of foreign law devolved, as it were, to their various international offices. They wouldn't worry too much about the application of German law in the dispute settlement centres of major London law firms, because they can turn to the German office for advice on that particular point. That may be so. But nevertheless, it's a little bit surprising to find such a view so strongly held. And there was also, in my experience there, a very strong statement on the part of the Association of British Exporters to the effect, which rather surprised me, that the Sale of Goods Act had attained a degree of perfection which rendered it superior to anything else. And this put me in mind rather of some of the extreme statements made in the 18th century about the perfection of the British Constitution. It's simply a matter of faith, isn't it? But above all, I think the real problem comes from the attitudes of the commodity trades. And that's the most significant thing that I shall want to concentrate on in the next 15 minutes or so. So now, what I propose to do is to set out the position of English law in the commodities trades before I then turn to some of the concerns expressed by the Financial Markets Law Committee. I'll then turn to the reasons why it is that the commodities trades stay with English law to the extent that they do. And I'll conclude by saying something about non-commodities, not very much, more to the effect that I do believe that the CISG outside the commodities trades is a perfectly acceptable instrument establishing a balance between buyers and sellers, and I'm strongly in favor of its adoption for that reason, leaving the commodities trades to look after themselves in the way that they already do. So now, the dominance of English law in the commodities trades. Well, I distinguish first of all between dry contracts dealing with grain, soya, matters of that kind, and wet contracts dealing with crude and refined oil. So taking dry contracts, first of all, you have most dominantly the Grain and Feed Trade Association, which by its own account is responsible in its contract forms for well over 80% of international trade in grain. I don't think there's any good reason to dispute that. And it's essentially a little operation in Lincoln's Inn Fields in London, but that's just the managing core, if you like. The association itself is located in 98 countries worldwide, and it has 1,900 members, running from arbitrators, brokers, traders, to, of all people, fumigators. And GAFTA and FOSFA, which is a very similar body dealing with vegetable oils and similar products, invariably provides for the application of English law, and in a clause called the domicile clause, invariably excludes the CISG. They also exclude Incoterms, but that's a different story. And when it comes to wet contracts, you'll find too that these are not the products of trade associations, but they are promulgated by the major oil companies. And even here, English law plays a very substantial part. So to take examples that are freely available on the web, if you look at Repsol, the Spanish company, Total, French company, Chevron, an American company, Neste, the Finnish company, they apply English law in their bulk oil, crude oil dealings. So patriotism doesn't come into it. Well now, why is this so? I think the most important thing to understand is that these commodity trades are not simply physical dealings in goods. They are essentially speculative transactions. You have what's called the phenomenon of string trading. And before I bring that on, let me introduce you to perhaps the only joke that I know in the world of commodity sales. It concerns a buyer of a large quantity of sardines who, having taken delivery of the sardines, then complains bitterly to the seller that the sardines are inedible. And the seller responds, well, you've misunderstood the nature of the contract. This wasn't a contract for eating sardines. This was a contract for buying and selling sardines. So the great majority of parties involved in especially the dry goods trade are taking a speculative position. They buy and they sell. They never see the goods, and quite often they don't see the documents if there's a truncated delivery of documents to the end buyer in the chain. And this is highly characteristic of forward sales, which are very commonplace in the commodities trade, the dry commodities trade, with delivery dates of 1 to 2 months in terms of the stretch, and contracts negotiated many, many months in advance. And when it comes to the crude oil trade, you do have spot sales there. The spot isn't to be interpreted literally. It typically means something for physical delivery within a month, but you also have forward selling as well. And when you have forward selling, you have contractual strings developing. Now, the point about contractual strings is that to make the string work, you need to have uniformity at all points in the string. There are differences, of course, relating to price, but the description of the goods, the place of shipment, the dating of the bill of lading, and the applicable law have to be the same in order for there to be a smooth transition from one end of the string down to the other end. And if you had different laws popping up at intervals in the string, then that would disrupt the transaction or the group of transactions. And another point to bear in mind with particular reference to the CISG is that quite often you will have within that string contracts between parties resident in the same jurisdiction. And that, of course, takes you outside the CISG, which requires buyer and seller to be resident in different states. So if you were to bring in the UN Sales Convention into the commodities trade, there would be very significant difficulties when it came to the operation of sales strings. So let me now turn to the Financial Markets Law Committee. Well, first of all, what is it? It's essentially an authoritative body that serves as a kind of watchdog in the City of London, looking at threats to legal certainty as they might affect the financial markets, typically chaired by a retired judge from the Supreme Court or formerly the House of Lords. And they issue reports from time to time, and some years ago they looked at the CISG. Now, they are a body that has a particular concern about certainty, and I'll come to some of the difficulties in a moment, but let me first of all connect the CISG with the area of their concern, which is the financial markets. They were particularly concerned about derivative transactions that could be physically settled, because many such transactions allow for the parties to convert the abstract into the concrete, to take an actual delivery of a commodity rather than settle the matter in terms of a financial difference on the due date of settlement. And the question here would be, would the CISG come in at the point of conversion? Might it come in even earlier still if there was merely the possibility of conversion? And I don't think their concern was sufficiently broadly expressed, because in my discussions with CISG confrères, especially from civilian jurisdictions, they say to me, why should you necessarily interpret goods in the UN Sales Convention as amounting to physical goods? Why may they not be abstract goods? So by that line of reasoning, even a pure derivative dealing with, as it were, the emanation of a concrete thing would be susceptible to the CISG. And one always can respond to concerns of this kind by saying, well, Article 6 just exclude the CISG, but this kind of argument doesn't seem to carry the day. Now, why was the FMLC so concerned? Well, I've mentioned certainty for one thing, but needless to say, they were very concerned about the role of good faith. They were aware of a difference between Article 7.1 and Article 7.2. In the latter case, there is, of course, the possibility of good faith being seen as an immanent general principle, but they never quite clarified that matter properly. They were also very concerned about fundamental breach and the need to establish fundamental breach under Article 25, which is very much and exclusively an effects-based test. It's a test that does not allow, as such, consideration to be given to the character of a contractual term. It's very much effects-based, and it marks a clear departure from the previous uniform law, which had a particular rule applicable to market-based transactions, allowing for something like the essence of the contract. And when you come to the end of the Financial Markets Law Committee report, you see the dog whistle being blown to the effect that the adoption of the CISG might very well imperil the position of the UK, its special position, and bring with it a risk that London would lose its edge in international arbitration and litigation. And that's a clear warning to the potential legislator that we should not go down that road. Well then, why do the commodities trades favour English law? It's not about the Sale of Goods Act as such, in my view. In my experience, it's quite rare to find any reference to the Sale of Goods Act in commodities transactions of sale. If you go through the pages of Lloyd's Law reports, you won't see many references to the Sale of Goods Act. There are obviously, as I've mentioned, concerns about fundamental breach. There would be some concerns also about cure, concerns too, and more particularly about the possibility of curing defective documentary presentations and the effect this might have upon, for example, a CIF transaction and the seller's obligation to tender a bill of lading dated at the point of shipment. All of that is certainly a possibility. But I think we have to start with the history of the commodities trades, and I'll focus now on the dry side because forward selling in the oil market is a much more recent phenomenon. To find the origins of the GAFTA contract forms, you have to go right back to the 19th century. And you start off with the Liverpool Corn Trade Association. And it all starts there, and it's been going on for well over 100 years. So now, why is this? Well, there has developed over time a sort of symbiosis of contract form and legal decision. So to the extent that a particular point is made in a judgment, which is acceptable to the trade, the form remains unchanged. To the extent that the trade doesn't like what the courts have done, the form is then modified. And so it goes on from year to year, decade to decade. A recent case involved the trade not liking a view taken by the court, by Mr. Justice Andrew Smith, on the seller's right in an FOB contract to substitute an already nominated vessel. The question there was whether time had to run again or whether the substitution could build upon the original notice, and the judge, I think, got it wrong, and the form was then changed to show that the judge had got it wrong. The view taken really, and this ties in with certainty, is that you shouldn't distort the form and the law to deal with the purity of the particular case. You should let the law take its toll upon the actual problem before it. And if that doesn't satisfy the trade, then the trade changes the form. This is the respect for certainty that Lord Mansfield in particular, and he was no reactionary, stressed in the 1770s. Merchants regard certainty as the most important thing. In connection with that, interpretation, especially when it comes to the standard forms, which have got no negotiating hinterland, is essentially a matter of pure law. Now, when it comes to bespoke contracts, where there is a kind of matrix of fact, you're looking at a mixed fact and law question. But when it comes to the sort of contracts that we deal with here, where there's no real prior negotiation, where it's done essentially by email or telex or telephone, we can treat interpretation as a matter of pure law, and the contract form is almost like a piece of private legislation. So for these various reasons, English law has been used. It's not a matter of mere path dependency. It's well established and entrenched, and it's based upon a structured relationship between the trades and the judiciary. That, to a degree, is diminished nowadays in view of the way that arbitration is kept out of the judicial system, except in unusual cases. But nevertheless, this is where we are. And the question then is, why should traders want to change the position they're in? Now, one of our speakers today, Bruno Zeller, has said, and I hope I'm not misquoting him here or parodying his view, that traders should realize they're on the wrong side of history if they resist uniform law, because uniform law is going to carry all before it. It's where we're going. Well, if you have Article 6 of the UN Sales Convention, the answer is yes, but only up to a point. And I don't think we should adopt either anything like a Marxist view of false consciousness, namely that traders don't know what's good for them. So we are where we are, if I'm going to coin some sort of awful phrase. And I have to lead this particular point by just stressing how conservative the marine-based trades are. It's not just business of charter parties, bills of lading, and so on. Goodness knows the degree of conservatism there is enormous. It's in trades associated with the marine element. And we're talking about commodities now, because commodities were planted in countries where they were not needed by and large. So they had to be transported by sea to places where they were. So now, there you are. That's the commodities trade, why it's not going to change in my view, and why it's had some kind of influence upon the stance of the UK. What do I think going outside commodities? Personally, I'm of the view that the UN Sales Convention, for reasons stated, is not a suitable vehicle for commodities, not for speculative transactions. But when it comes for physical transactions, it's the best thing going. Ewan McKendrick says it's a creature of its time, and yes, it is. And there may very well be problems with hardship and contractual revision, but I think these are much more likely to be problems in the construction industry than in the sale of goods trade. I would be very much in favor of bringing on the CISG. I think it's an evenly balanced instrument. I don't regard it as weighted in favor of buyers. If anything, I think it offers a great deal to sellers. It offers a great deal to sellers in the sense that they can be fairly confident once goods have been transported to another country that the goods will not be thrown back against them because of a breach that's less than fundamental in character. Other features of the CISG, I might just conclude by cutting back to something that Ewan was talking about. There are obvious difficulties relating to Article 79, but I think what really lies at the heart of Article 79, more than anything else, is the extent to which the common law principle of strict liability was brought into the convention even at the expense of the civilian approach, which in terms of damages liability favoured fault. In civilian systems, there is by and large a distinction between retribution or taking the contract apart and imposing liability and damages, the latter depending upon fault, whether presumed or otherwise. So the real problem when it comes to Article 79 is how you accommodate strict liability within the convention as a whole, and whether you give any kind of leeway, as it were, to the prior requirements in many civilian jurisdictions of fault. I'll leave it there. I've probably gone on for too long.